We'll now take up case number 21-1204, Tomlinson versus State of Florida. Go ahead.
Good morning, Your Honors. I'm Daniel Tibbett. I represent Kevin Tomlinson. This may seem at first blush to be a simple statutory interpretation case. This is a free speech case. Everybody who wants to speak out in this country, at least in the state, whether for or against any public or private figure, will be affected by this decision. You cannot commit the crime of extortion without speaking to somebody, without communicating the supposed threats at issue. This country has always afforded people the right to communicate, to speak. Our founding fathers obviously enshrined that right in the First Amendment to the Constitution. This is the case despite the fact that by definition, speech that the government seeks to prosecute is speech that the government does not like.
If this is a free speech case, why don't you cite the First Amendment anywhere in your brief?
The brief and the brief does talk about the speech issues and the entire overbreadth, vagueness.
I'm looking at your table of contents, and I don't see a citation to the First Amendment to the United States Constitution. Am I missing something?
I'm not sure what's in the table. I came into this case. I did not personally write the briefs in this case. However, the case cara carte from this court that this case stems from was a case where there was an overbreadth vagueness challenge. That's discussed at length in the briefs, and the.
So here's what we said. Here's what we said in cara carte. Quote: Defendant's contention that the extortion statute is impermissibly vague by virtue of the term malicious is without merit. This court has repeatedly upheld the terms malice and malicious against a vagueness challenge. So it's a vagueness case, right?
The vagueness challenge is that's ultimately a First Amendment.
Look, we can talk about the First Amendment, but it seems to me like what we as a court need to decide in this case is what maliciously and malice means in the context of a criminal statute, and whether malice here means malice in the legal sense, namely, as you and your opponent have briefed, malice in terms of intentional action in an illegal way, or malice in the sense of hatred. And it seems to me like before the notice you filed this morning, everything we had been reading was about that question. So I'm kind of interested in solving that one before we start talking about the First Amendment.
Well, I think they're related questions. I think if the court looks at the statutory interpretation question of what does maliciously mean in this statute, it's not defined in the statute. The court this court in cara carte cited to this court's decision in Gaylord that found the same maliciously language that was not defined at that time in the child abuse statute to mean actual malice, to mean that you had to act with ill will. Then the legislature came in and said, no, that's not what we meant for child abuse, and they put in the statute for child abuse maliciously means legal malice. They never did that in response to the cara carte decision with extortion. The difference between child abuse and extortion is that child abuse does not, there's no constitutional amendment that's implicated in, you don't have a right to abuse your child. You do have a right to speak. That's why when the, statute is somewhat ambiguous, the First Amendment comes into play, because the court has to realize that the whole point of cara carte was to protect the extortion statute from a First Amendment challenge, from the entire statute being invalidated because it was, overbroad and vague and ultimately violated people's First Amendment rights. So, without a...
I'm struggling to understand how the First Amendment issue relates to the question that's actually presented here about whether malice means actual malice or legal malice.
Well, the way that it relates is that actual malice protects the statute from being unconstitutional under the First Amendment, because it sets a high, the First Amendment has the whole true threats thing. You cannot, you can.
And you, sir, you argued this in your brief? You argued that the statute was unconstitutional in violation of the First Amendment?
No, I'm not. I don't think the statute is unconstitutional in violation of the First Amendment.
If we interpret it the way you think we should interpret it. And this was argued in the brief.
No, I do not think that the statute is unconstitutional. I think that the statute has an actual malice component, and it has been long held that you cannot, or that you can criminalize speech that has an actual malice component to it. So I'm not.
I think what we're getting at is that a lot of the cases that you do in fact cite and that the government has joined issue with are actually not free speech cases at all. They're due process cases. Vagueness is about when, because an act, a legislative act, speaks with unconstitutional breadth, it criminalizes conduct without notice to me. Right. That it is in fact criminal conduct as understood because it is, violative of, the law and what has been enacted as a guide to, legitimate behavior. That's not a First Amendment question. That's a due process question. And I don't know how this whole discussion helps you win the case at all. What I was hoping we would engage in, and what I think we still have time to engage in, is a discussion about what to do with the question presented, whether there is a sufficient guide if we say that the statute criminalizes malice in the legal sense to people's behavior so that prosecution can happen in a way consistent with due process. That's what I think the issue is in this case.
Okay. As to that issue, I think that with a statute not telling people what is the malice standard.
Do you accept the premise that at common law extortion it just required what we're now calling legal malice?
I accept that.
I think if you accept that premise,
I'm sorry?
If you accept that premise, then I think the constitutional stuff goes out the window. And what you're left with is, what did the legislature do when they used the words that they used here? Either choice would be constitutionally permissible. Does the word that they used mean legal malice, or does it mean actual malice? I mean, I think you started off by saying this isn't just an ordinary statutory interpretation case. I think that your strongest case is to make it a statutory interpretation case. And so the question for you is, why, given the tools that we normally apply to understand words in statutes, why should we read the word maliciously here to mean actual malice rather than legal malice?
Okay, let me just say one thing.
Counsel, I'm sorry. I'm going to jump on you a little bit here, too. Don't forget his question, but I have a follow-up question to that. Our common law understanding of malice has historically been legal malice. Would you agree with that?
No, I would not. What I was agreeing with in Chief Justice.
So you do not, hang on, you don't agree with that. Okay, so our common law understanding of malice, you say, if you don't agree that it was legal malice, you're saying that it's actual malice, historically.
Well, that issue was not briefed either. What I was talking about with the common law extortion.
Whether it's briefed or not, this is my question to you. Would you agree with that premise?
I have not researched the common law
so
history
take my word for
the
it.
word
So
malicious.
historically, common law has treated malice as legal malice. And when we use words in a statute, it is presumed that we use the meaning that was given at the common law, unless the legislature specifically says we're going to adopt a different meaning. So if that is all true, why then should we interpret in this statutory context the word malice to be actual malice instead of legal malice?
Well, I think that the premises that Your Honor is coming from, if you look at the common sense definition of malice, what people understand malice to be, it is not just intentional. And when you're talking about giving notice to people of what is prohibited, what is not prohibited, when, you know, someone's talking to another person on the street, when they say someone's acting maliciously, they don't mean, you know, they did something intentional. They mean they did something evil. They did something
Well, let's
motivated
talk about
by
the dictionary
spite.
interpretation of malice. If you look at Black's, dictionary, if you look at all the Merriam-Webster, in the legal context, what the first definitions that they lay out are always the legal definitions of malice. I think, if memory serves me correctly, there's only one legal dictionary that says, oh, and there is also actual malice, but it doesn't lead off with that.
I mean, every dictionary that I've looked at, including Black's, talks about both, definitions. So I'm not sure. I don't agree with the premise that every dictionary only talks about the legal malice. But what I'm saying is, and the cases say this too, that actual malice is the common sense understanding. When you're looking at interpreting a statute, a criminal statute, and giving people notice of what is allowed and what is not allowed, I think that the court needs to, and the court has said that you should look at, what are we notifying people of? If the legislature came out and said, okay, what we mean by malice is just intent, then we have a different issue. Then someone's going to challenge it on the grounds that I was talking about before, and the court would make a decision. But since they haven't said that, I think the defaults should be what is a common sense understanding of the statute.
The Chief's question.
Yes. So I'm sorry. Can you repeat? Because I got lost when I got asked another question. Can you summarize for me?
No, I think I mean, it's kind of what you've been talking about, which is basically using the normal tools of statutory interpretation. So we have the canon about the common law meaning. We have the ordinary meaning canon. I mean, are you saying that we should basically, because of the notice issue here, go with the ordinary? What you're saying is the ordinary meaning rather than the common law understanding?
Thank you for refreshing my memory as to your question. It's a good question. I think that's part of it, but also if you look at the actual statute, the actual language of 836.05, which I think everybody agrees that the starting point for any statutory interpretation is what do the words say. It has two separate limiting clauses. One of them is for the extortion that it has to be maliciously, what we're talking about. The other one that specifically says, in the statute, it has to be done with the intent to, intentionally do wrong to somebody, essentially. So, the government, the state, is equating those two things. If the court says maliciously in this statute is just legal malice, the word maliciously does no work because the statute already has the other clause that talks about intent. So the legislature does not, and this court does not presume that legislatures put words superfluously into statutes. The fact that they wrote maliciously as an additional limiting factor on when criminal penalties can be applied to somebody in addition to the intent language that's in the statute tells the court that the legislature, wanted more before they were going to punish, before they were going to approve punishing Floridians for speech. So
I mean, if we just concentrate on the ordinary meaning of the word, maliciousness, it just seems to me, just without looking at anything else, just thinking of the ordinary meaning of the word malicious, to me, it would include something like Black's dictionary says, which is ill will, wickedness of heart, something more than just doing it. It seems to have, the word malicious to me seems to have that component to it. Something wicked this way comes when I do this, right. That type of thing. So that seems to be your strongest argument here, it would seem to me.
Yeah, I mean, I think you're, Justice LaVarga, I think you're right. I think when any two Floridians are talking to each other and somebody says, oh, this person did something malicious, that's what they mean, and if that word is in the statute, absent further guidance from the legislature, It should be interpreted that way.
It would have been nice if the legislature had said when we say maliciousness, we mean X, Y, Z.
Right, and they know how to do that, and they did that in the context of the child abuse statute after this court ruled in Gaylord and in Reed. So
Counsel,
the fact,
what would the jury instruction under your reading of actual malice? What would the jury be instructed? What would the jury have to determine?
you must find that the defendant acted. It would. I mean, it's in the current one as one of the current jury instructions. I understand why the court took this case, because it doesn't make a lot of sense to have a standard jury instruction that tells a trial judge, well, choose one or the other. But it would be what's in there right now, as the actual malice option, which is you have to find that they acted with ill will, hatred, spite, evil intent. I think there's four. There's four words, and it's or four phrases, and it would be what's in there right now, and that's what it should be. And that was argued at trial, and the defendant should have an opportunity to have a jury determine beyond a reasonable doubt whether the state met that element in this case. So we would ask the court to reverse and remand, and to hold that extortion requires actual malice.
Good morning. May it please the court. My name is Ksenia Smuchkovskaya, Assistant Attorney General, appearing on behalf of the state of Florida. Legal malice is the proper standard for extortion. Extortion is about greed, not hatred. The purpose of the extortion statute is to prevent one person from unjustly enriching himself by threatening another's person, property, or reputation. The extortion statute does not state that the criminal conduct must be motivated by ill will, hatred, or evil intent. Instead, it requires that the offense have been committed with the intent to extort money or pecuniary advantage.
Counsel, let me ask you this. You would concede that ordinarily, in interpreting a statute, we first look to the common sense of the words being used.
Your Honor, we do look at the text first. Correct.
Pardon?
We do look at the text, at the term.
I understand, but we look at the words and the common sense of the words that are being used. Is that correct?
Correct, Your Honor.
And so, and you would further concede that the sense of that you are advocating for here, legal malice, is not the common sense of the term malicious, right?
No, Your Honor, I would disagree, because if we look at the term maliciously in the context of the statute, the ordinary meaning of it would be intentional and unlawful. We no longer look at the statutory term in isolation when we interpret the statute. We look at the specific context that term is used, and the plainness.
So you're saying the context here would point away from the common sense of the term to a technical sense, which is legal malice, right?
Correct, Your Honor, but I would still argue that common sense here is more wrongful. The ordinary meaning is wrongful more than with evil intent.
So if I understand your position, Ms. Smuchkovskaya, it is that this word just has two meanings, right? And both of those meanings are pretty old, and one of them is perhaps more common in colloquial usage. But there's another perfectly good meaning to this word, and it's an old usage, and it means with an illegal intent. Is that a fair rephrasing of your argument?
Yes, Your Honor, but also the respondent is arguing today that based on the context of this statute and that mens rea provision included in the statute, it gives the different meaning to legal malice.
Because this appears in a statutory text about extortion, we have a textual clue about which of these words well-recognized meanings to use. And that is the one that means with an illegal or impermissible, ill will kind of intent. And then, if I'm understanding you correctly, the statute goes one step further and says, by the way, because an element of the crime is to demand money, then we know that's more evidence that we should use this other meaning of the word malice here, right?
Correct, Your Honor, because we must exhaust all the textual clues when we interpret a statutory term.
But going back to Justice Kennedy's commonsensical approach to interpreting the word malicious. When I think of the word malicious, I'm not thinking about intent. I'm thinking about somebody doing something ill will, something wicked, something not even illegal. I don't even think about illegal, just something wicked, something in that sense of the word. That's what I think about malicious. So now you want us to say, well, it actually means intentionally, it actually means illegal. I don't get that from the ordinary sense of the word. If you want to change the meaning of the word, I guess that's fine, but that's not my sense of it.
Well, Your Honor, interpreting the term maliciously in the context of extortion would lead to absurd results. Because first, it would essentially prohibit penalizing the extortion of strangers or the victims with whom the defendant appears to have positive relationship with. It would also lead to or even encourage defenses and arguments that are solely based on subjective feelings of a defendant instead of a pecuniary interest. Extortionist conduct is driven by greed, by desire to take advantage. It's not a personal crime. It's not about hatred. In fact, nearly every district to consider the question agrees. The legal malice is the proper standard for extortion.
But let me ask you this, and this has to do with the question of exactly what actual malice means. Does it necessarily require hatred, or can it just be some other? Obviously, hatred involves an evil purpose, but can it also involve just a different sort of evil intent?
Your Honor, actual malice is defined as evil intent, ill will, hatred, or spite.
But those are alternatives. It covers kind of a range of things that include evil intent as one of the things in the range of what it signifies.
Your Honor, including actual malice definition in the jury instruction might cause more confusion. What is evil intent then? How evil needs to be the intent in the context of the crime of extortion?
Yeah, I mean, so go ahead.
The crime of extortion includes to basically threaten to expose another to disgrace. Basically to impute any deformity or lack of chastity to another. And all those crimes seem to have some type of component of evil intent. And me threatening to expose person X to the fact of lack of chaste character or something like that. That's seems to me a commonsensical approach to it.
However, to penalize a defendant's or perpetrator's act or behavior, that type of behavior needs to be unlawful, not just full of hate, not of spite. The measurement is, does the extortionist has a lawful right what he's demanding or what he's claiming? I think it is really important that there is a mens rea provision that guides this court, that the intent is to extort and get money.
Well, but how do you answer counsel's argument that based on what else is in the statute, that under your interpretation, the interpretation you urge, that the malice isn't really doing any work because it's already in there? What legal malice would signify is already embedded in the other provisions of the statute. I think that's counsel's argument, right?
Well, not necessarily, because in the mens rea provision, it's the intent to extort money, but it needs to be an unlawful act, unlawful threat. Someone should have no legal right to demand money. So I not necessarily agree with the counsel's point. And besides, the At common law, the crime of extortion never required actual malice.
So in this case, if the defendant had been promised some contractual percentage of a listing, and he had said, I'm going to go public with the fact that you breached this contract, then he could not be prosecuted for extortion, right? Because he would have a legal right to receive what he was demanding. Is that fair?
He would have a legal right to obtain the money and demand the money.
So then the work that the word maliciously does is it excludes that case from prosecution, right? Am I understanding you correctly? Okay.
Could you talk about, it seems like your case, if we have the lenity issue that's kind of hovering there in the background, that we know that it comes in kind of at the end of the interpretive process, but it seems like you're asking us to put a lot of weight in this kind of common law canon as a trump of the ordinary meaning canon, because if they were kind of equally plausible understandings of the term, and there's either side could point to a canon, then you would think that lenity would require us to side with the defendant. Why is that wrong?
No, Your Honor. The respondent urges this court to look at the text and exhaust first all textual clues. And by looking at the text, we see the mens rea provision, and it's respondent's position that it does clarify. The focus is on the intent to extort and money.
But you keep assuming what the whole case is about. I mean, unless you say that, really to say that the relevant context is that it's a criminal statute, basically you're just saying that that any time you're dealing with a criminal statute and there's an established common law understanding that basically becomes the clear meaning of the term. I mean, it sounds like that's really what you're wanting us to say.
It's one of the arguments, Your Honor. However, also the canon of interpretation of the statutes to make sure they don't lead to absurd results, the respondent suggested as well, because it would eventually allow extortion of strangers or the victims that defendant never met in person, doesn't have any subjective feelings against.
I don't understand how that is consistent with the element of, in the definition of actual malice, it requires evil intent. Because you can have an evil intent with respect to strangers.
Well, Your Honor, I think the actual malice have that subjective component to it, which is legal malice is very straightforward, intentional and unlawful threat with the intent to extort money. And as Justice Muniz has pointed out, the rule of lenity comes to play only after all the interpretive tools have been used and exhausted. And I don't think this is the case where we need to even go there, just based on all the clues are given by legislature in the statute and the common law definition.
But you do have this issue that this is not the sense you're urging, may be supported by the common law, but it is contrary to the common sense of the term, which is where we start. So, I mean, it's an interesting case. I mean, because you've got these different things that play into the interpretive question, but we have this statutory directive from the legislature to apply this rule of lenity. So that's
and really, I mean, criminal statutes are an area where, arguably you would be disinclined to kind of go with sort of a technical / expert understanding and maybe shade things more towards sort of the person in the street who's, the average person running around doesn't have any clue what the common law understanding of malice was.
Well, Your Honor, going back to the rule of lenity, the respondent doesn't believe that even the application of rule of lenity will necessarily is in petitioner's favor. First, under the case of this, facts of this case, petitioner acted both with actual malice and legal malice in this scenario. So the facts of this case are unique. Both of the definitions would have resulted in the conviction. And there could be scenarios where actually the prosecution would be in position where it would be easier to prove hatred instead of legal malice. So then not necessarily the rule of lenity would result in the what the petitioner is asking here today.
Well, but you certainly think that the other standard would be more favorable to the actual malice standard in this case would be more favorable, right? And in general, wouldn't it be more favorable to the defense?
I think it's very case specific, Your Honor. It really depends on the content of the communications that the extortion is made. It's very case specific and applicable to this case. I think the acts of petitioner and the threats made in this case, both standards, actual malice and legal malice, would absolutely justify the conviction in this case.
Go ahead, please.
I mean, legal malice is a subset. I mean, wouldn't every case that satisfies actual malice also satisfy legal malice, but not the other way around?
Your Honor, there could be scenarios, again, where there are threats full of hate to extort money and where the state would be able to prove hatred, but those communication would be legal, certain demands that the other party would be entitled to demand, whether it's a contractual obligation. I hate you, I will sue you, right? But if there's a contractual obligation, if one hates the other person, is still entitled legally to that money, but it's full of hate. The state can establish hate. Does the communication contains hateful threats? Other lawful? Well, that person is entitled to money owed. So I think it's very factually driven. So not necessarily the rule of lenity weighs in petitioner favor in every scenario.
Could you address the issue? Say we disagree with you. I don't know that we will. I don't know that I will. But say that happens. So then we get to the question whether the impact that this error had in this case. We explain why, even if the instruction was wrong, that here there shouldn't be a reversal.
Should be or shouldn't be?
Shouldn't be. You don't want a reversal, right?
I don't want a reversal. The third district absolutely is correct. In this particular case, again, the facts of this case is that petitioner acted both with legal malice and actual malice. He acted out of hate and spite and jealousy, and his threats were intentional and unlawful. So based on that, his conviction should be affirmed.
So your position then is the jury would have convicted them in any way?
That's correct, Your Honor.
Under
Absolutely.
either scenario?
Absolutely, Your Honor. And if this court doesn't have any further question, respondent respectful asks that this court approve the third stage decision. Thank you.
Okay. So first of all, as to the common law issue of what did extortion mean in common law, I guess I learned something by reading the state's brief, but I don't think that has anything to do with this case because the extortion crime at common law was a completely different crime having to do with public officials seeking benefits or something. So it doesn't mean anything about what the common law understanding of this crime that we're talking about is. So I'd say that. As to the idea that there's going to be, well, the state talked about all the, some lower courts have said, well, this is not a crime about hatred, this is a crime about greed. A finding that that the state has to prove actual malice is not inconsistent with this. It is not my argument that everybody who is guilty of extortion must, hate their victim. If someone, you have the prototypical scammer that, maybe, a stock guy that's getting on the phone and, working at a boiler room or whatever, and he's trying to get, he's just trying to get money and putting people into terrible investments. He doesn't hate those people, but he's acting with an evil intent. He knows that what he's doing is not what he's saying to those people. He would have, actual malice. But the state, that's an element of the crime. So
how do you respond to the issue of that the state in this case proved malicious under either interpretation and the jury would have convicted them in any way?
Well, that's just not the way that the law works. If a jury if the court gets an element, if the trial court gets an element of the crime wrong, then it's the state's burden. It's fundamental error, and if that element was disputed at trial, then it's reversible. The only time it's not reversible is if the element was not disputed. In this case, the defendant's intent was the entire issue at trial. There was no doubt about what happened. It was recorded. His whole argument was basically that, I was trying to engage in, I was basically acting like a civil lawyer before I got a civil lawyer, and I was trying to settle, this real estate complaint via this proposal that they pay me, and I go and drop the complaint. So his whole argument was I wasn't acting with, evil intent. Now, what would the jury find? I don't know, but that's what we need to find out. We cannot just assume that, he's guilty because the jury found that he had intent, the wrong standard. And that's what the cases say, is if the element is wrong and if it's disputed, it's reversible. The other thing I would say about the absurd results argument the state's making, look, I know the court doesn't obviously love my First Amendment issue argument, but if the court makes this standard legal malice, this is about speech. Extortion is about speech. There are going to be challenges based on the First Amendment, like there was in Caracarte, which does cite the First Amendment. That would be an absurd result if then, the whole extortion, whether it's, legit extortion or not legit extortion, gets, found to be unconstitutional by some federal court down the road. I do think that's something the court should keep in mind. So ultimately, the court should settle this split. The court should give trial courts guidance, and the court should follow the common sense definition that what people mean when they say malice. And hold that the correct standard is actual malice and should reverse and remand.
Thank you.
Thank you.
We'll now stand in recess for 10 minutes.
All rise.